Ladies and gentlemen, good afternoon. It is my privileged honor to be here. And I would like to thank Professor Catherine Lepau for the invitation and for giving me the opportunity to speak in front of you. In the next 20 minutes, I will introduce to you about the occupational health and safety protection for migrant workers in China. I mean domestic migrant workers in China, and also brief you about the recent legislative change to the occupational health and safety regime. So here are the outline of my presentation. I will first talk a little bit about the labor mobility or the labor migration in China, domestic labor migration. The second that I will take some time to brief you about the occupational health safety legislative framework. Then I will talk about the occupational health safety protection for migrants, especially the challenge that we have and the dilemmas migrant workers have in terms of access to occupational health and safety protection. So here is the labor migration in China. In China we have we create a household registration system, which is very commonly seen in socialist countries as a kind of a control of the labor migration. And the population was divided into urban part and into rural part. So the original intention of household registration system is to discourage this labor migration. But after the opening up in the late 1970s and early 1980s, the government needs to develop the economy. They need a huge amount of workforce. So they slightly change the policy and begin to ease the restriction upon these labor migrations. So we now see this migration from rural to urban migration. Here is you can see the map. This is the map of China, and most of the migration are from rural to urban, or within one locality, or from rural west to urban east, or from rural central China to eastern urban areas. So that's the most the migration route taking place in China. And as I have shown here, in China, it is as late as 2007 when we have employment promotion law. The law provides that domestic migrant worker status as a prohibited grounds for discrimination. So it is as late as 2007 that migrant workers begin to have the equal treatment under labor employment law and also under the social security law. It takes a long time for them to have this equal treatment. And here the following diagram is about the trend of labor migration, and you can see that in the past 10 or even 15 years, the migrant workers, their numbers are on the rise, definitely. And now, last year, we have a total population of domestic migrant workers of 260 million. But you can see clearly in recent 2 or 3 years, the growth rate is dropping. It is still on a rise, but the growth rate is dropping. So here are the education attainment of migrant workers. Well, I make some distinction between the younger generation of migrant workers and the senior generation of migrant workers. Senior, I mainly mean in their 50s or in their late 40s. Well, for the younger generation in their 20s or 30s, or sometimes it can be their, the children of the senior migrant workers. There is slightly difference between these two generations of migrant workers. So you can see their attainment. For the senior generation, many of them only have, only attended primary school. While for the younger generation, many of them, or more than half of them, has attended, the junior high. So that's kind of different. But it is still the education attainment or educational attainment for the migrant workers overall is still very low. You can see, half of them only receive the junior high school education or below. So, the educational attainment level may indicate their like skills or their awareness of occupational health safety hazards. So here are some about migrant workers concentration in terms of the industry. You can see in the past 5 or even 10 years the concentration, most or at least half of migrant workers, they are concentrated in manufacturers industry, in construction, and some of them are concentrated in service industry. While comparatively speaking, like manufacturers, constructions are more dangerous than service industries in terms of the workplace injury and fatality. Here are some workers compared with their employers are vulnerable. While migrant workers are especially vulnerable in terms of the imbalance in power. So most of, as I have mentioned, most of the migrant workers, or majority of them, are engaged in we call it 3D jobs, dirty, dangerous, demeaning jobs, and and also many of their employment is informal. These, the short-term contract, long working hours, high turnover rate, and many of them are self-employed. And the third one is, there is among these migrant workers, there is overall speaking, there is a lack of grassroots mobilization, and also, the collective bargaining mechanism largely is absent. I mean, there is slightly difference between the younger generation and the older generation migrant workers in terms of grassroots mobilization. But overall speaking, it's very weak. So that's the first part about labor migration. Now let's move to the second part about occupational health safety legislative framework. In China, we do not have an omnibus Occupational Health Safety Act. The long tradition is that, the legislature will divide occupational health safety into two parts. One part is occupational safety. The other part is occupational health. And we also regard, the special labor protection for female workers and for underage workers as also part of, the scope of, the occupational health safety regime. So you can see we have our act on prevention and on preventing and treating occupational disease. That's in 2002, and we have Safe Work Act, that's about occupational safety in 2002, and we have a special regulations on the protection for women workers in 1988. So overall, these laws, regulations set up an overall prevention structure. There is a organization taking charge of occupational safety issues. There is an organization taking charge of occupational health issues, and there is another organization while taking charge of the compensation issues. As we all know, as a government, it will have different, particular policy levers in order to ensure the health and the safety of workers. Mainly we can divide it into occupational health safety policies and compensation policies. In China, that's the same, right? And occupational health safety, there can also be like, regulation, prevention, consultation, regulation, enforcement, prevention, and education, they have different tools in their toolkit. In China, that's the same, right? So you can see that we have one organization taking charge of these tools or these activities in the field of occupational safety. That's Work Safety Administration. We have one organization, that's Department of Health, in charge of these activities in field of occupational health. And we have our Labor Department, and it set up a Workers' Compensation Board, taking charge of the compensation. And also Labor Department is in charge of the special labor protection for female workers. So now here are the demerits with the old structure. There was a consensus with this old prevention structure. There is separation of occupational health and occupational safety. Well, now I understand for many of you, you may have questions or you may be skeptical. How can it be effectively to split occupational safety from split occupational safety and occupational health? Finally in China, we also have this kind of question regarding the effectiveness of this separation. And the second is that since there is separation of occupational health and occupational safety, and they are rest with different organizations, so there is a kind of imbalance in terms of the enforcement. Well, in China, Work Safety Administration is very powerful. It have a lot of tools in terms of enforcement. So the enforcement in field of occupational safety is pretty good. So you can see from the following diagram that sorry. Which one? Okay. Sorry. So yeah. So we can see from this following table that the accident rate or the incidence of accident rate had been a drop. There is a very consistent evidence that there is drop of the work accident rate, but you can see that there is a continued increase in the incidence of occupational disease numbers. Well, I have to confess that maybe the number or the statistics on the occupational disease is not very reliable. Think about the very serious issue of underreporting and very serious problem with claim suppression. But if we assume that the rate of underreporting and the rate of claim suppression is the same, so it may indicate some of the trends or the effectiveness or ineffectiveness of the old prevention structure. So overall speaking, the old prevention structure is a failure in terms of occupational health. Beginning in 2011 or 2012, the top legislature made revisions to the occupational health and safety legislations. It revised, the occupational, the Act on Prevention and Preventing and Treating Occupational Disease in 2011, and it revised the Safe Work Act in 2015, and it revised, the Special Regulation Protection of Female Workers in 2012, and established a new prevention structure. So you can see, compared with the previous one, now the regulation, enforcement, education, prevention, these activities of in fields of both occupational safety and occupational health are now rest with one single organization. That's the Safe Work Administration. Well, so it is split from the previous portfolio of the Department of Health, and it now still and also it adds special protection on the portfolio of the Work Safety Administration. Well, now the Health Department is still in charge of occupational disease determination, and now the Labor Department is in charge of the compensation issues. So with this new structure, so the merits is very obvious. Now it enhance the enforcement, both in field of occupational safety and occupational health. As I mentioned, the Work Safety Administration is very powerful in terms of inspection and investigation. So now, in fields of occupational health, compared with the past, it stepped up its effort in terms of its enforcement efforts. Well, with regard to the demerits, so you may still see that, yes, so the occupational health safety is still in separate from the compensation. Well, I noticed, very interestingly, there is a report from WorkSafe BC 2014, after the investigation into the sawmill explosion accident. So it said, the key element of world-class occupational health safety regime is that we have the compensation and occupational health safety rest with one single organization. Well, I understand, their statement or their conclusion have one precondition. The precondition is that, the coverage of the compensation, workers' compensation should be very high. In this case, if we have, compensation and occupational health safety rest in one organization, it will be very effective in terms of administrative efficiency. While in China, as you know, I will mention later, I'm running out of time, I will mention later, the coverage is still very low. The coverage is still very low. So I don't think now, the separation of occupational health safety and the compensation is a demerit. While in the future, if the coverage has increased like into, higher than 90%, that's the cases here in Canada in the 6 jurisdictions, right, which have one organization taking charge of occupational health safety and compensation. That's pretty high, the coverage. That's their commonality, right? So I will now quickly move to the next one. In order to help you understand, I think Professor Eric Tucker of York University Law School's article is very instrumental and illustrative to help you understand the Chinese system. He built on the worker citizenship. There are 2 dimensions. One dimension is the participation right, another dimension is social rights. So by mentioning social rights means workers' rights to the government-enforced mandatory minimum occupational health safety protection. So in China, we have the social rights. Workers have the social rights, but there is almost no participation rights. So I would say in China, the model is direct state regulation model. Now, let's move to the third part very quickly. So I will review some of the challenges and dilemmas we still remaining in China. The first one is weakness with the direct state regulation model. The effectiveness of direct state regulation model depend or hinged on the enforcement efforts of the government. If the government is good at enforcement, this model can be very effective, right? Well, China is notorious for the relaxed enforcement in terms of labor standards. So it caused a lot of problems. One testimony to my statement is that, the low coverage of workers' compensation, which is compulsory. That means every employer should participate, but there is a very low coverage rate. So that's the testimony of the weak enforcement. The second one is, the limited coverage. I have already mentioned limited coverage under OHS law. Our OHS law or regime is based on the employment relationship. Only workers have employment relationship. That mainly means, in the formal employment can be can have access to this OHS protection. So in China, agricultural workers are excluded. They are self-employed, so that's not recognized under Chinese labor employment law. They are excluded from the occupational health safety law protection. And in China, another one is there is a very low awareness of hazards. In China, this morning our colleagues talking about the hazards of asbestos. Well, in China, hazards of asbestos was not well known, and it's still widely used in China. Like asbestos were banned in North America, in EU, but China, along with India, is still one of the two largest consuming countries of asbestos. And workers in China, they have misunderstanding of this hierarchy of hazards control. PPE is at the bottom of the effectiveness of the hazard control. While in China, both employer and migrant workers, they believe in the effectiveness of personal protective equipment. So the last slide is in China. We have the workers do not have adequate access to remedy in case of OD. So I have should use the number or the incidence of occupational disease. It's very low. Like each year there are like 20,000 nationals. That's unbelievable, right? It is estimated there are at least like 6 million workers with numerical nuisance, but most of them cannot recognize under our very strict occupational disease determination mechanism. Okay, in the interest of time, I will stop here, and I will happy to answer your questions later on. Thank you very much for your attention. Yeah.